other things that I want to point out beyond that, it's really important to get an estate plan in place to avoid a lot of problems, a lot of costs after your death. And I know a lot of reason people don't do it is because they don't have to. There's no sense of urgency to get an estate plan in place, and they don't feel like their estate is that complex, or they're just thinking there's a lot of reasons why not to do it. Oh, plus, the expense of paying, a lawyer to do your estate plan. So maybe people go online and try to do it themselves, which may or may not be better than having a will. It really depends. But one of the things that I want to share with you, see, at ELG Estate Planning, we help people protect assets from all sorts of creditors, state, taxes, long-term care expenses, and none of that will be accomplished if you do your own will or if you don't have a will. So I'm just going to give you an example of why probate actually might be a really good thing for you. Are you married, or do you have a child who either has a disability or lifestyle issues, or are you worried that a divorcing spouse of your child will end up getting whatever your child inherits from you? There's a lot of reasons that you would look at and say, should I protect money for who will be inheriting from me? So I'm just going to give you a spouse situation. It applies the same if you have a disabled child or any other child who you might want to protect. And when I say child, I'm talking about adult child, but if you have a minor child, even more so the reason you need to have a will so that the court would know who to appoint as that child's guardian. So a really simple example here. You're married and you and your spouse together are not particularly worried about much of anything. But you went to an estate planning lawyer who understands asset protection and government benefits, an elder law attorney. So you and your spouse, let's say you have $1 million of assets. $500,000 is what your house is worth. And you've got $500,000 in other investment accounts, IRAs, 401ks, that sort of thing. And you went to a law firm who prepared for you a will that contains an asset protection trust. We do that all the time when we are dealing with our senior clients. But let's say you're 40, let's say you're 50, let's say you don't have any diagnosis of Parkinson's or Alzheimer's or any, you're not worried about long-term care. Even though once you hit 65, most people do worry about long-term care, but you're younger. So you have $1 million of assets, you and your spouse. And in your will, there is a trust that can come into existence if it's needed to protect assets. Sadly, what happens is you and your spouse are in a car accident, and let's say you are killed and your spouse survives, but they have become disabled in some way. They can no longer work. Perhaps they're a paraplegic or something. Something happens to them that everything just went awry. If you have the kind of will that I've been describing, you will want a probate because we can protect 1/2 of the assets. It's a community property estate. You've done a community property status agreement. Deceased spouse dies. Their half of this $1 million estate, or $500,000, is going to go into an asset protection trust for the surviving spouse. So the surviving spouse can no longer work. They need asset protection. We likely will take $500,000, that liquid assets, put it into a trust for the survivor. Surviving spouse has $500,000 in this special trust. $500,000 is their house. If they need the state to pay for their care, which they likely will, they qualify for Medicaid benefits. No spend down required. They are eligible for benefits despite the fact that they own a $500,000 house and they have $500,000 in trust. Why is that? How does that work? It works because as an elder law attorney and an elder law firm, we understand what the government benefit eligibility rules are and how to protect assets. So we basically can protect $500,000 and the surviving spouse is eligible for Medicaid. In order to do that, they had to have the right kind of will, which is what we prepared for them, and they need a probate. This is my example of why a probate might be a very good thing. So probates in Washington are what we call non-intervention, means the court isn't involved with every decision. The court simply signs an order that says this is a good will, and the personal representative or the executor is authorized to act without a bond, without intervention of the court. So they do their job to fund this trust through the probate process. Yes, there are legal fees. There are legal fees that are going to be involved for preparing the estate plan, and there are legal fees that are going to be involved with funding this trust. So that is why people shy away from it, from doing an estate plan, is that there are going to be legal fees. In this situation, though, what I hope to convey to you is we've protected $500,000 of assets, and there is eligibility for the state to pay for that long-term care for the rest of the surviving spouse's life. Yes, that cost money in the estate plan and in the probate, but frankly, legal fees of $5,000 to $10,000 or in that range for those types of services are well worth that outcome. Estate planning, I'm not saying everybody needs a probate. What I'm saying is understand whether probate is the right thing for you. As often as we will set up an estate plan to go through probate to protect assets like I just described, we often will set up an estate to avoid probate so there are no costs upon death. What's right for you, that is really going to be dependent upon your situation, but I do encourage you to seek out a very qualified estate planning and elder law attorney to provide you answers, because everybody's situation is different.